A man walks into his adjustment of status interview this month, terrified. He's read every headline since May, every Reddit thread about denials and detentions. He's convinced this is the day his case gets destroyed. 3 days later, his green card gets approved. Not months later. 3 days. And he was from one of the very countries that had spent half the year on a federal immigration ban list. That's the real story most people aren't hearing right now, buried underneath 6 months of terrifying headlines. Tonight, I want to actually add up everything that's happened since May, every policy, every rule, every scary Reddit post, and show you what's genuinely true versus what's just noise, because the gap between the two is bigger than you'd think. Let's start with the policy that scared people the most. Back in May, USCIS released a memo that basically declared adjustment of status an extraordinary form of relief, something you now had to prove you deserved, not something you simply qualified for. The immigrant community went into full panic mode. This felt like the end of adjustment of status as anyone had known it. Here's what actually happened on the ground. According to immigration attorneys handling these cases every single week, the overwhelming majority of applicants, including people who've been out of status for a decade, people with prior work authorization violations, are still getting approved under this memo. Most USCIS field offices appear to be largely ignoring it in practice. One attorney described a colleague's interview in New York City where the officer flatly said the agency hadn't given them real guidance on how to apply it. So, as far as that office was concerned, it effectively didn't exist yet. That's anecdotal, not an official policy statement, but it lines up with what multiple attorneys are independently seeing. Denials under this specific memo remain genuinely rare. What's far more common instead is delay. Interviews that happened months ago with approvals still sitting in limbo, officers citing ongoing background checks. Frustrating, yes. The sledgehammer denial everyone feared? Mostly not what's actually happening. Now, here's a story that shows exactly how fast this can flip the other direction. Remember the 39-country immigration benefits pause, the one that put green card and citizenship applications from countries like Venezuela, Haiti, and Iran into limbo? A federal court struck it down. USCIS didn't immediately comply. It took a second court order specifically forcing the agency to show exactly how it was complying with the first one before approvals genuinely started moving again. And that's not theoretical. That's the man from the opening of this video, approved 3 days after his interview from a country that had spent months frozen out entirely. Quick pause here, because if you have a pending adjustment of status case right now, and separating real risk from internet panic genuinely matters to you, go ahead and hit subscribe and turn on notifications, because we're going to keep tracking exactly how these policies play out in practice, not just on paper. Now, let's talk about the one that's actually serious, because not everything on this list turns out to be overblown. The public charge rule taking effect September 18th is the real deal. It replaces the narrower 2022 standard with something dramatically broader, and the rule itself openly states the government expects millions of immigrants to voluntarily drop Medicaid and other benefits in anticipation of it. Unlike the May memo, attorneys aren't shrugging this one off. If you have a strong case ready to file and you're debating timing, filing before September 18th genuinely matters here, because this rule applies based on the date USCIS receives your application, not when they decide it. And here's the newest layer, one that hasn't gotten nearly enough attention yet. USCIS quietly changed its long-standing policy of issuing a request for evidence when an application is incomplete. Under the old approach, if your case was filed a little early, missing one final piece of evidence you knew was coming, officers would generally ask for it. Under this new policy, that safety net is gone. Your application can simply be denied outright, no follow-up letter, no second chance. One attorney handling primarily marriage-based cases said this doesn't change much for genuinely strong applications, but for anyone filing a borderline case hoping to strengthen it before the interview, that old strategy just became significantly more dangerous. So here's the honest, weighed-together picture, because none of these policies exist in isolation, and taking them one at a time misses the actual pattern. The scariest-sounding policy, the May discretion memo, is mostly not being enforced the way it reads on paper. The 39-country ban reversed, with approvals genuinely flowing again after a second court order forced compliance. The public charge rule, real, serious, and worth acting on before September 18th if your case is ready. And the new evidence policy, quieter than the others, but arguably more dangerous for anyone filing an incomplete case and hoping to fix it later. Layer all of that together, and what you get isn't the sledgehammer that headlines in May promised. It's something slower and more selective, roughly one significant policy shift every 6 weeks, chipping steadily at the edges of the system rather than collapsing it outright. Attorneys handling these cases are also seeing something newer and more unsettling underneath all of this. People who lawfully became permanent residents years ago receiving notices to appear, attempting to claw back green cards through full removal proceedings rather than the narrower rescission process that would normally apply to a case like that. It's not common yet, but it's a pattern worth watching closely because it suggests where enforcement might be heading next, even while the headline policies themselves are being applied unevenly today. So, what should you actually take from all of this if you have a case moving through the system right now? First, don't let a scary headline alone convince you your specific case is doomed. The actual data from attorneys handling hundreds of these cases says the vast majority, even for people who've been out of status for years, are still getting approved. Second, take the deadlines that are genuinely real seriously. September 18th for public charge is not hype, and if your case is ready, filing before that date matters. Third, if your application is anything less than rock-solid complete, understand that the safety net of an automatic follow-up request just weakened significantly, so build your strongest case the first time rather than planning to patch it later. And fourth, if you're a lawful permanent resident with anything unusual in your immigration history, don't assume old status is untouchable. That assumption is exactly what's being tested right now in a small but growing number of cases. Here's the bigger picture worth sitting with tonight. Immigration policy right now genuinely is shifting faster than most systems are built to communicate clearly, which creates the exact environment where fear spreads faster than facts. But fear and facts aren't the same thing, and conflating them can cost you just as much as ignoring a real deadline can. The system isn't collapsing the way Panic Online suggests. It's also not the stable, predictable process it was 2 years ago. Both of those things are true at the same time, and understanding the difference is exactly what protects your case, not blind optimism, and not blind panic either. Before you go, make sure you've hit subscribe and turned on notifications, because we're going to keep separating real policy risk from online noise as these changes keep rolling out roughly every 6 weeks. If this video helped you actually understand where things stand right now instead of just feeling more anxious, share it with someone navigating this exact process, because clarity right now is genuinely rare, and it matters. Thanks so much for watching. Stay informed, stay prepared, and take care.